morning, students. I hope all of you are well. Today, we are going to discuss the significance of the beneficiary principle in light of the exceptions and ways to avoid it. I hope all of you have gone through the slides that I uploaded on Times. Now let's play a game. I have a pen with me, and when I throw it and you catch it, it's your turn to speak. I'll go first. Now, in order for a trust to be valid, there must be an identifiable beneficiary so that the courts can decree a performance of the trust. This was established in Leahy, an Attorney General of New South Wales. Additionally, a trust requires that the property be held on trust for a beneficiary such that the beneficiary acquires a proprietary right in the property, and this was seen in Saunders and Gautier. However, the principle has been called into question because of the judicial interpretations which have resulted in exceptions and certain ways to circumvent it. Now let's discuss the significance of the beneficiary principle. Firstly, it is significant because of the principle's practical workability. Sir William Gant, in Morris and Bishop of Durham, stresses that the beneficiary principle is vital in guaranteeing that an individual has the locus standi to bring a claim to enforce the trust. This arguably is the basis of the principle and its main significance to the sphere of trust law. Justice Roxburgh highlights that the beneficiary principle helps visualize the growth of equitable obligations which nobody but the beneficiary can enforce. Therefore, this principle clearly allows for the practical ease of trust to be enforced and protected by the courts. Secondly, the significance of the beneficiary principle cannot be denied since it acts as a corollary to the law of certainties. Joanna Nigel purports that in validating a trust, the beneficiary principle is used to prove that human beneficiaries are present, while certainty of object then focuses on its clarity. Both principles work in tandem to ensure a trust's efficient management and supervision, and are considered in determining the scope of beneficiaries as illustrated in Region Kibu. Therefore, the beneficiary principle is clearly needed to give effect to the cardinal rule of certainty of object in ensuring the validity of a trust. Grace, I hope you have studied this chapter.
The beneficiary principle is such a significant concept since it also guarantees that the trust property will be vested onto an identified beneficiary within an identified period of time, preventing the trust from existing perpetually. This is known as the rule against perpetuities. The main rationale behind this rule is to prevent the trust property from being tied up indefinitely and also ensures that the restrictions set up in a trust would come to an end after a stipulated period, where a sui juris beneficiary would then have the unfettered right to deal with the property as they choose. The rule against perpetuity comprised of sub-rules beginning with the rule on remoteness of trust vesting. This sub-rule demands that a beneficiary be sufficiently defined in order for a future interest to vest itself upon a prescribed period, preventing the trust from existing indefinitely. The application of the remoteness rule can be seen in the case of Leahy against the Attorney General of New South Wales, where the court held that a trust property vesting itself after a reasonable period of time would be considered void. In the case of Re Chen Sem Lin settlement, the beneficiary principle prevented the infringement of this rule since the period of which the property would be transferred to the beneficiary was clear and precise, which was when he attained the age of majority. Moreover, in his notable thesis, Professor Gui outlines another sub-rule, which is the common law rule on the inalienability of trust property. It states that no interest shall be good if it vests longer than 21 years from its creation. Despite the extension made in the UK through the enactment of the Perpetuities and Accumulations Act 2009, Malaysia affirms the traditional common law approach. In Re Li Moi Chai, the lack of clear beneficiaries and an uncertain period for when the religious ceremonies were to take place failed the inalienability rule. Hence, both sub-rules compromising the rule against perpetuities are heavily reliant on having clear beneficiaries determined to prove a valid trust, proving the significance of the beneficiary principle. Furthermore, the beneficiary principle also prevents trusts that arise for an undefined and abstract purpose. The general principle is that non-charitable purpose trusts would be void due to the lack of its enforceability. Viscount Simond in Leahy states that in abstract purpose trusts, no beneficiaries would have immediate possession in the rights of the trust property. Thus, it would be unclear as to how the trust would be managed and enforced. In Reshaw, a trust to discover a new alphabet to maintain peace between nations was deemed unenforceable due to the lack of identifiable beneficiaries that would have interest in the trust. Therefore, the beneficiary principle remains significant since it prevents the formation of abstract purpose trusts. The crux of the beneficiary principle is that it ensures the enforceability of a trust. Thus, it helps to strike down trusts made for capricious purposes. Ultimately, this would be in line with public policy, since the beneficiary would be able to reap the trust property without any unreasonable difficulties being placed on them. This was illustrated in Brown against Burdett, where an unreasonable blockade of requests made voided the trust. Hence, the significance of the beneficiary principle is that it prevents an unduly burden being placed on the beneficiaries themselves by striking down trusts made for capricious purposes. Felicia, on to you.
Thanks, Grace. I have to disagree with you, as there are various ways the beneficiary principle can be circumvented. This can be through people's trusts, gifts, and contracts. The first way to circumvent the principle was seen in Reed Denley's trust deed. An objection was made as there was no beneficiary with locus standi to enforce the trust, rather than an objection on the purpose, as a purpose trust would be void if it were abstract or impersonal. Lord Gough found that if the express purpose trust is directly or indirectly for the benefit of individuals, it is outside the mischief of the beneficiary principle and can be upheld. He referred to them as individuals rather than beneficiaries, suggesting a people's trust. In one view, criticism has been faced whereby the approach has created uncertainty in the law surrounding the beneficiary principle. Professor Chalmers expressed that purpose trust is an area of the law which seems to lack coherence and rationality. In another view, the decision is described as an attempt to liberalize the orthodox concept of a beneficiary. In other cases, the approach has been followed and applied to other circumstances, such as in Re Lipinski, where Justice Oliver applied the approach for a gift to an unincorporated association as a superadded direction to the principle. Furthermore, Justice Vinalot in Re Grant's Will Trust found that the approach did not widen the principle, but rather amounted to a discretionary trust, benefiting a class of beneficiaries, those of whom could apply to the courts to enforce the trust. Thus, there are orthodox seti key trusts. Therefore, the principle still stands and is significant. The approach is an extension of the principle itself, as when extended to the limit of its potential, it would validate many more trusts. With regards to a gift, where a specific purpose has been assigned to a sum given as a gift, as seen in Re Osoba, the court found the gift as absolute, the purpose as being merely a motive for the gift, and is not a limitation restricting what she is entitled to. In Re Boas, Justice Nord found that the fund is devoted to improving the estate, and improving the estate for the benefit of the persons who are absolutely entitled to it. The ascertainable beneficiaries were entitled to the entire sum, whether or not spent specifically on planting trees. However, a trust is only so much as is necessary for the purpose, as in Re and Trust of the Abbott Fund. Once the ladies had passed, the trust for the purpose of maintaining them had not been fully exhausted, and the money went on a resulting trust to the people who subscribed the money, as the daughters of the deceased were not intended of becoming absolute owners of the fund. Thus, a gift would seriously undermine the doctrine of the principle when one examines the practical circumstances of the modern world. It is apparent that some of the rigors of the traditional prohibition against non-charitable purpose trusts can sometimes be avoided by careful drafting. Finally, in cases where a contract is involved, such as in Conservative and Unionist Central Office and Burrell, an employee holding funds subject to a condition of using them in a particular way does not amount to a trust, but a relationship of an agent. the beneficiary principle does not apply, and the holding of funds is for the benefit of the unincorporated association's purposes, and clearly not for their personal purposes. Sarah, on to you. Catch.
Thanks, Felicia. There are various exceptions to the beneficiary principle. The first category of exceptions are known as anomalous exceptions. It is important to note that nobody is beneficially entitled under these trusts. Thus, it cannot be enforced. There are 4 types of anomalous trust. Firstly, trust for the construction or maintenance of monuments and graves. Malik v. President illustrates that the courts will uphold the trust to erect a monument, although there was no beneficiary to enforce it. However, the trust would fail if it offends the rules against perpetuity. In Muslim v. Binkle, the gift of £200 failed as no time period had been stated. Secondly, for trust for the care of specific animals. The court in Reading upheld a gift for 50 years for the maintenance of animals. Nonetheless, Reading was criticized for offending the rule against perpetuity, as animal lives were considered in the perpetuity rule. However, animals can live longer than 21 years. This was at odds with V. Kelly, which established that the measuring life must be human life. It is submitted that defining perpetuity periods using animal lives would cause uncertainty. The third exception is trust for the saying of masses. Recalls illustrates that a trust for the saying of masses in public would be charitable and therefore valid. However, in Bourne v. King, the court distinguished between public and private masses and held that a trust for private masses could be upheld, provided it qualified as a valid purpose trust. The fourth exception is trust for miscellaneous cases. In V. Thompson, a trust for the promotion of fox hunting was valid as the gift was clearly defined. However, fox hunting has been restricted under the Hunting Act 2004. Thus, a future trust promoting fox hunting would not be upheld. However, it is arguable that it is more accurate to regard these anomalous trusts as mere powers held by trustees. McFarlane asserts that these cases are not an exception to the beneficiary principle, but an exception to the principle that a valid power is not to be spelled out of an invalid trust. This was seen in V. Thompson, where the courts recharacterized the invalid purpose trust which offended the beneficiary principle into a trust for the benefit of the party otherwise entitled. This was coupled with the trustee's power to spend the fund on specified purpose. Thus, the significance of the beneficiary principle is not undermined. Nonetheless, Lord Evershed and V. Endicott has affirmed that the courts would not extend these categories of purpose trusts. He reasserted that the cardinal principle in trust law was that a trust required an ascertainable beneficiary to enforce it. This undoubtedly affirms the significance of the beneficiary principle. The second exception to the beneficiary principle is trust for unincorporated association. An unincorporated association has no legal personality. Thus, as a general rule, the association cannot own property. The property will be transferred to a person to hold that property for the association. There are different means of transferring property to an unincorporated association. Firstly, as an outright gift to present members. Where an outright gift is property which cannot be divided, the transfer can be deemed as a gift made in a way that members of the association are joint tenants in the title of the gift, as seen in Riley-Pinsky. Secondly, the property may be transferred as a trust for present members. The property would be held on trust by a person for the benefit of the association's members instead of for the association's purposes, and this could be a valid people trust, as seen in Redelli. Thirdly, as a trust for members as an accretion to the club's capital used according to the club's constitution. Property transferred to the association's benefit may be placed under the control of an association's officer subject to the association's constitution, as seen in V. Retcher's Will Trust. Lastly, as a transfer subject to a mandate to use the property according to the club's constitution as an agent of its members. The property will be transferred to an association's officer to pursue the association's purposes. Thus, the person is an agent of the association's members. Therefore, this would fall under contract law as seen in Conservative Association v. Barrow. On to you.
Thank you, Sarah. The third exception to the beneficiary principle is charitable trusts. The requirements of a charitable trust is that the trust is certain, that the trust is for a charitable purpose. Please refer to slide 12 for the categories of charities. Next, the trust must be exclusively charitable. And finally, the trust must be held for public benefit. Moving on, Miss, I'll now discuss some of the issues with the beneficiary principle. As mentioned by the others, there are many exceptions to the principle, so much so that the entire basis of the doctrine, that being the insurance of certainty, is seriously undermined. As Moaft, Bean and Dewar explain, quote, so great are the number of exceptions to the beneficiary principle that it was open to doubt as which was the rule and which was the exception. Even so, the doctrine too falls foul to some key fundamental issues, such as the possible absurdity arising due to assumptions pertaining to perpetuity, again undermining its central importance. There are numerous examples of this taking place, such as children who can magically give birth, or the often quoted magic gravel case. In Rewood, the testator directed his trustees to carry on his business as a gravel contractor until gravel pits at question had been worked out, and then to sell and divide the proceeds among identified family members of the settler. Now, despite the reality that there certainly would be an exhaustion of gravel, the trust was held to be void, as the drafting of the trust meant that theoretically the trust could exist in perpetuity. As such, and in holding the trust to be void, the court rather remarkably assumed that the gravel at question would continue to be dug indefinitely. Such instances of incongruity were even discussed within the Law Commission report on the rules against perpetuities and excessive accumulations, highlighting the strange results which can ensue. Another instance of complication is the seemingly manufactured desire to invalidate purpose trusts. Now, as stated earlier, the distinction between people and purpose trusts is a thin line, easily blurred. Yet why is there a need to invalidate purpose trusts? As pointed out by Professor Paul Matthews, although the rules against purpose trusts is derived from a procedural point, there is, quote, no magical reason why it must be maintained in modern society. This appears to be further reinforced in light of the ease in which the principle may be circumvented in certain situations, highlighting the fact that the beneficiary principle is not an immutable rule. So what may be seen from this refusal to allow purpose trust is a frustration of the wishes of a settler or a testator who may merely want to benefit a legitimate public object or a useful social experiment, which doesn't simply fall within the purview of a charitable trust. Due to this gap within the existing framework, and the fact that trust law is, quote, essentially a product serving a variety of commercial needs, a number of academics have put forth the enforcer's principle in order to rectify the situation. In essence, it is argued that it is enough if the settler in his trust deed especially confers a locus standi on an enforcer interested in the furtherance of the settler's specific, non-charitable purpose. This enforcer therefore ensures that the trustee is brought to account for any breach of trust. As such, the use of this principle does directly conform to the principle that there must be an identified individual who could enforce the trust, while also allowing a purpose trust and greater flexibility. Now, this is not a novel concept. As recounted by Paul de Portales, a number of jurisdictions allow for purpose trust via the utilization of the enforcer's rule. For more information, please refer to slide 13. Nevertheless, despite the growing push to permit the operation of purpose trusts, there are some concerns regarding the effect of its allowance. Indeed, these offshore developments illustrate a, quote, turn in the whole axis of the trust, with the possible consequence that a settler may be able to mitigate tax by alienating trust property, reducing the revenue ultimately gathered by the state. Even so, the disallowance of purpose trust does not account with the changing realities of a globalized world. Thus, the absolute rejection does set odds with growing sentiments. Possibly an increased flexibility in the beneficiary principle is needed in order to, quote, satisfy the needs of practitioners subject to modern commercial and physical realities. So, Miss, do you think the beneficiary principle is still significant?
Thank you. Despite the exceptions, ways to circumvent the rule, and the criticisms of the beneficiary principle, it is submitted that the beneficiary principle is still significant because of the beneficiary's role in enforcing the trust relationship. The beneficiary's equitable interest cannot be mimicked by any third-party enforcer, and the courts would take greater initiative to protect the beneficiary's interest and ensure that the trust obligations are exercised to the best of their ability. Furthermore, this principle provides certainty by preventing perpetual trust and abstract and capricious trust. In conclusion, the beneficiary principle's significance should not be lightly dismissed. Justice Winslow, in the case of Ri Cheong-Ki-Hu, affirms this by stating that no principle perhaps has greater sanction or authority behind it than the general proposition that a trust, not being a charitable trust, in order to be effective, must have ascertained or ascertainable beneficiaries.